Let's proceed with one of the more important facts of life that deals with child for immigration process. This will be displayed in our popular segment called Business and Immigration Law Updates, a presentation of the Khurana Law Firm. Here, the Chief Practicing Attorney is Attorney and Counselor at Law, Mr. Ramesh Khurana. The moderator here is Attorney Kenneth Haber from Boyd's, Maryland. Let's see their interaction in this segment.
Hello, my name's Kenneth Haber. I'm a former Assistant United States Attorney and a former Senior Attorney of the Office of Inspector General, United States Department of Health and Human Services. With me today we have the distinguished Ramesh Khurana. Welcome, Ramesh.
Thank you.
Ramesh is a renowned immigration attorney who literally has clients from across the world. When they come here, they need to have immigration statuses and other immigration matters handled, and Ramesh is the one that many come to.
Thank you so much, Ken.
And he's here to answer some of our questions concerning immigration on the Capitol Forum. Welcome. Welcome, Ramesh.
Thank you.
Ramesh, are you ready for some questions?
Yes, I am.
Very good. Could you please explain who's considered a child for immigration purposes and give a couple of examples?
Yes, sure. I'll be very happy to do that. In fact, this is a very important issue to know who's considered a child under the immigration law. So, as you asked me to give you a few examples, now let us say there is a child who's born in wedlock. So, he is a child, and a child genetically born out of wedlock, he is considered a child. And when we are talking about a stepchild, because sometimes you know that people get married second times and their spouses have children already, in that point of time when they are filing petitions for their spouses, now they would like to make sure that spouse can bring her children along. So, those children or child who has to come with mother must be under the age of 18 when the marriage took place between the husband and the wife. So, the marriage must have taken place when the child or children were under the age of 18.
Does it matter how old they are after the marriage is?
You know, that is also an important issue. Again, once the marriage has taken place, within the age the children become entitled. But if those children, they cross the age of 21, then sometime it may become an issue. But so long as marriage has taken place when the child is under the age of 18, because practically if you see, they are not going to take much time. Because the process takes, when the wife and the child, they are sitting overseas, it takes about a year, 10 months to 1 year. So, they are going to file right away, but it must be made sure child is under the 18 when the relationship is established. And similarly, when you are talking about the adopted child, adoption must have taken place when the child is under the age of 16. And when the siblings are to be adopted, then one of the two siblings can be over the age of 16, but not over 18.
Out of age.
And then of course, there are certain requirements that the child must have lived in the physical and legal custody of the adoptive parents. So, that is also another condition, but we are not going to the chapter of adoption, but since we are talking about a definition of a child, I thought I would just mention is for the purpose of adopted child must be adopted under the age of 16. I receive these kinds of calls every single day. Like some parents want to adopt children, and sometimes they would say, oh, the child is 17, 18. So, I said, when did you complete the adoption process? Oh, in fact, I have to start the adoption process now. I said, you are already out of luck. So, these points are to be kept in mind in regard to the eligibility of children for the purpose of immigration.
That reminds me of the child that, there's a failure to launch, they say, they don't get out of the parents' house. And nowadays it gets older and older, but they're out of luck
Right.
in those circumstances.
That's true. Yeah.
What's the most important condition concerning a stepchild being considered eligible for immigration purposes?
Again, for the purpose of emphasis, when we are talking about a stepchild, I would like to say if the two persons have decided to get marriage, and if the foreign national spouse, if she has a child or children, and if they are under the age of 18, get married now, so that children don't cross the age of 18 before you have the marriage certificate. That is very important for the purpose of stepchildren.
Any particular reason that the government explained why this magic age of 18 is so critical?
I would say that this is the law, and you have to fix certain dates, and I think 18 is a pretty good age, and more or less a person becomes adult. Of course, otherwise the age for adulthood is 21, right? And for certain purposes, 18 age is considered to be a good age where the person can make one's own decisions. Even when we are talking about the eligibility of US citizenship or naturalization, any person who is 18 and above, that person can apply for citizenship. So, I mean, maybe that's the logic behind it. Because a person has to be of sound mind.
Right.
Yeah, and use some discretion. Probably a child of 18 can use some discretion to decide.
Right. It sounds like it's more of a barrier than a help at times, though, in terms of a family staying together.
You are 100% right, because if parents get married when the child is over 18, he is outside the definition of a child. He's not qualified to come with the parents, but that's the law.
Could if the man, the husband, was American citizen, married a alien whose child's over 18, could the husband, could he petition for that child under some status?
Oh, sure. Once that genetic mother or father gets a green card, then that person can file for the child. But it's going to take a longer period, because otherwise, if the child is covered under the definition of a qualified child, then there is no quota, and the child is also under the age of 18 within the definition of an immediate relative, and so green card petition gets adjudicated very fast. Otherwise, going to take long years depending upon the nationality of the person.
Can a child come into the country and live while the visa is pending?
Yes, can. This is a very beneficial provision in the law, that when the petition is pending, and sometime depending upon the processing times, these petitions which are under adjudications are taking much longer time, then a child can come on K4 visa, and of course mother can come on K3 visa as well. So yes, there is a provision which is a very beneficial provision, like instead of waiting overseas. But again, it depends. Nowadays the green card petitions are being adjudicated very efficiently. So in most of the situation, there is no need for K4 visas, because by the time you file I-130 and I-130 gets approved, and it goes through the NVC to the US consulate and interview is scheduled.
Let's see. Can you explain the concept of follow to join benefits?
Yes, can follow to join benefit is, let us say that mother is here, for whom the US citizen has filed the green card petition, and the child is living overseas. So you file the green card petition or adjustment of status for the mother. Then along with that, you also file the follow to join petition. What will happen? This follow to join petition, which is form I-824, it will also get approved at the same time when the green card petition is getting approved, and it will be sent through NVC to US consulate overseas, and that way our children who are there at the time of marriage, now they are covered under the follow to join definition. So this is a very good provision. This way a family can stay together. Under the follow to join, I recently handled one very complex case, and it's worth mentioning, Ken, since you take interest in all these kinds of situations, and I'm sure audience can also listen carefully. Most of the people who come on H-1B visa, their spouses get H-4 visa. So one IT guy who was working with a consulting company, his H-1B visa got denied, and with the result, H-4 visa also got denied. And when they got married, he had the priority date current, husband, but wife's priority date never became current. So fortunately, husband was on employment authorization. When the H-1B got denied, husband started working on EAD, but wife was out of luck. She had no status, and she kept on waiting for 2 years, thinking that she had no other option. She came and met with me a few months back, and when she explained to me her situation, then based on the green card approval, which was done 2 years back, I filed follow to join petition for the wife, which is by way of form I-824, which got approved in 4 months, and now it is being routed through the National Visa Center. But the challenge here is, because wife has incurred unlawful presence so far, and this unlawful presence is over 1 year, and for that reason she is basically barred if she goes out. But the moment she has to go out and appear for interview at the US consulate, now the consular officer will hand over a letter saying that you have incurred unlawful presence, but you are eligible to file for the waiver because she is the spouse of a green card holder husband. So then we have to file a waiver application. Unfortunately, the processing time for waiver application at this point of time is 6 months. So after the waiver application is approved, then she will be interviewed again and she will be able to come. But this follow to join tool is so advantageous, I was trying to explain, that we could use that in such a kind of situation where wife was going through a very difficult time. She doesn't have a driver license, she cannot work, and she is just sitting unlawfully, and she is scared like what will happen if something wrong happens. And the couple, they have a very beautiful child. So at least we found a solution through the tool of follow to join provision.
Very good. Well, there's a solution. I'm sure you're going to find it.
Yeah, you know, sometimes it becomes so difficult, you know, you do brainstorming, you do due diligence, and sometimes things are so difficult that nothing much can be done. You have to wait until law changes, because as we have spoken several times, immigration system is really broken at this point of time. It needs to be reformed, and hopefully one day certain good things will be coming in.
Well, I can't imagine that it's going to continue limping along very much longer, that somebody's going to do something.
Yeah, you know, at this point of time, 12-13 million people, now they are sitting here unlawfully, which is a very unfortunate situation.
It certainly is. It certainly is. It stymies not only the adults who came here unlawfully, but their children.
That's right. Yeah. Yeah.
When does a child have to apply for removal of condition on his green card?
First, it is important when the child is issued a conditional green card, when the marriage between the husband and wife that is less than 2 years old, now they give the conditional green card, and likewise child also gets the conditional green card. So, child has to apply 3 months before the expiry of 2 years to be eligible for that.
Well, I thank you very much for coming and explaining all those concepts. I'm sure that many people in the audience will have further questions. They should contact a competent immigration attorney, and I'd like to thank you very much.
Thank you very much. I appreciate that.
I thank you.